Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
And Justice Serve TV is on the air. What am I hearing? What is that?
You're on the air, and my phone decided to go rogue. It
Oh
went
my
rogue.
gosh.
Okay.
You put Siri on in a corner there. Put her in timeout.
No. I mean, I had the sound off, and literally my phone has gone rogue. It decided to give me. You know how I never get the alerts about our show? Well, I just got the alert about our show, but with the alert about our show came this voice out of selling something, and I had the sound off and everything.
Welcome to the world of AI. Hey, LKB, good to be back. What else is going on? Oh, wait, hold on just a second. Hold on. All right, a day wouldn't be a day on Karen Reed without some breaking news. This just happened, and we've got the opinion. We're not going to get into it now because we have an amazing guest. We may get into it a little later, but the headline is quite simple. As people will recall, there was a big back and forth appellate brief reply, and now a decision from the appellate court on the issue of whether or not double jeopardy had attached in the underlying first trial. I guess you're waving me off.
No, I'm not waving you off. I just tweeted out today the fact that there was a reply brief.
Yeah, the reply brief just went out yesterday, and it was all. Right. It was all the same stuff, we know, because they were denied at the lower level. Right. They brought it up, all the same arguments, and that, I'm telling you, as they say, the ink wasn't even dry from the clerk's stamp in receiving the reply brief yesterday. Today we get the court decision. Would you be shocked to know it was denied?
I was shocked that the court decision came down. I learned it from you about 5 minutes before we went on the air.
I think it's a good move on their part. It takes one more question out of the mix, right? You know, everybody's concerned about, well, what if that happens, after the jury is sworn in and then something, first of all, I don't think there was a chance in hell it was ever going to be granted because, hey, we have a second trial. Why don't we just do that and shut up about everything else? But I appreciate their need to bring it and appeal it. But now it's official. It has been denied. Okay, so now let's get on to more important things, at least as we look toward trial number 2 starting April Fool's Day, as we say, appropriately enough. Why don't you you're so familiar with our guest, why don't you give him a proper introduction?
All right, we have as our guest an amazing, I think, the best jury trial consultant, I will say, because it's not just a jury consultant, trial consultant in the world. His name is Richard Gabriel. Why do I say that? There he is. Why do I say that? He's been my trial consultant in major trials. He also does a lot of pro bono work for cases that we've been in. He's in California, so a lot of times it's hard to go East Coast to West Coast, East Coast to West Coast. But it's not just me. Everybody wants Richard Gabriel. Everyone. All right. He's he works with Michelle, who we had on in the past. But Richard's the man. Okay, he is it, and he has.
And you mean that in a non-sexist way?
And I mean that in a non-sexist way. And we hadn't seen each other since before the pandemic. And I saw Richard just before the ASAP Rocky case because he has this amazing project going on. And in introducing him as the most amazing trial consultant, and I'm telling you, the Spector hung jury, the ASAP Rocky case, and not guilty. He helped us in Hernandez. He helped in the Casey Anthony case. He helped in our pro bono case down in Tennessee that we had the guy who was wrongfully convicted on death row exonerated. I mean, he's all over. And someday we'll get into the history about why he is who he is, and it has to do with his mom. Okay, mothers, we rule. What can I say?
You do.
But in introducing him, I'd like Richard to tell us a little bit about his the new Justice Project, this title, what it's about, and then we can go on to the specifics of Karen Reed, which is why we're here.
Sure. Well, Linda, you are way too kind. It's been always a pleasure and an honor to work with you on all these fantastic cases, and I've been really blessed to be able to be in the work that I've done over the years. The Trust and Justice Project came about a couple of years ago when I started seeing plummeting attitudes towards the justice system on the whole. And it really concerned me because I work with juries every day. And to see people with that kind of cynicism walking in and even just dealing with, how do you get a jury involved when people themselves are skeptical about evidence, about science, about the law, about authority? These are things that we rely on in the justice system. And so I was like, well, not only, so we did a lot of polling. We did a national poll. We did a bunch of focus groups because we didn't want to just find out what those attitudes were, because they reinforced, yes, people are more cynical about our justice system. We wanted to find out why. And we wanted to find out, number one, not only why, but what can we do to turn this around since we rely on it. So we spent a lot of time talking, and we've been going around the country now talking about the results, and that people truly do believe in the justice system. They just believe that it has a lot of problems and needs a lot of reforms. And there's a lot of suggestions, a lot of great groups out there who are doing things to address it. But as we all know, the justice system kind of works very slowly. And so that's the challenge here, is how do you implement these reforms and then start turning around the attitudes?
Richard, what were the top two things, or a couple of things that you can think of that were consistent that people kept coming back to?
In that project, there were, one of the things that was fascinating is we did tests across all kinds of different demographic groups: Black, white, Hispanic, ultra conservative, ultra progressive. And what was surprising to us is across the board, the attitudes towards the justice system were pretty universal. So even people who you would kind of expect they'd have different attitudes, they really didn't. So it was universal across that. That was the sort of the big thing. The most dismaying thing, and sort of the big takeaway that I took, is that the public on the whole doesn't feel that the justice system is their system. They don't feel it really serves them. They feel it's primarily a system for judges and lawyers to do their thing. And as a result, that's where they feel disassociated from the system. And that's the challenge, is saying, this is your system. And I think there's a lot that we can do in the justice system to start making, especially jurors, but also clients themselves, feel like it's our system. We have better understanding of how the system works. We have more participation and just a better ownership that it is our system.
What is the one suggestion that you came away with that you speak about in terms of when you go around the country now with all these groups? And I was on a panel, you were kind enough to put me on a panel with the Chief Judge of the state of New York, I explained to people, our Supreme Court is not called the Supreme Court, but if you were thinking about it, it's our top court. It's our Supreme Court, but it's not our Supreme Court. And amazing attorney generals and people and federal judges who deal with this every single day. What's the one thing that you have come away with that says, this is the one thing that needs to be fixed, and how do we fix it?
Well, I think the first thing really has to do with just starting to have conversations like this with those chief judges, with those, the civil rights organizations, with different groups, to find out what are the reforms that are needed. I think education is key, really starting even in high schools and in colleges, teaching people about the justice system. And since I work with juries, I think we need to be much more jury-centered in our trials. A lot of times the juries feel kind of like they're on the outs, they're picked, they have to serve, and they're sort of sitting back while the judge and the attorneys run the court. And there's lots of reforms that will help them feel like they have more participation and better understanding of how these trials go about. So those are the main things that I think can be done to help our system.
Yeah, there's one thing you guys have both seen, I'm sure, that I really appreciate. In some states, the jurors get to ask questions of a witness. If everybody's done their questioning, the jurors will pass questions out, and if the parties in the court approve, the witness will be asked questions. You can't get much more participatory than that, Richard, right?
That is, for me, Michael, the key reform that really should be universal now. Because how can you be insured at the end of the day if the jurors actually getting it, unless they're allowed to actually ask questions? And there's been a lot of research that's been done on this. It doesn't necessarily prolong the trial. The questions are, for the most part, on point. There's a few questions that the judge goes, no, I'm not going to ask that because it's either prejudicial or it's irrelevant. But for the most part, I'm tracking this, and quite frankly, it allows the attorneys to also know what's going through the jurors' minds at any
Sure.
given point in the trial.
And what am I missing? And yeah, I think it's great.
Yeah.
Okay. Well, speaking of things missing,
And speaking of jurors,
segueing into the Karen Reed part 2 coming up here, just give us first your general thoughts about this extravaganza.
Well, I think extravaganza is probably a good word for it. I mean, look, Linda's participated in a lot of high-profile trials. We kind of treat them like, oh, it's just another one of those, but they're not. They're anything but ordinary. So the extraordinary part that I think of, especially coming up, starting Monday, is how do you select a jury in a case like this? I mean, that to me is the biggest question here. There's been so much publicity and so much controversy around not just the evidence in the case, but the conduct of each of the parties in the case. And there's been so much of a media campaign, quite frankly, on the defensive side, that, to then sit down in a jury selection process and say to jurors, what do you know about the case? Any opinions have you formed? And then, oh, by the way, can you set those aside and decide the case based on the evidence? It's kind of an impossible situation. And I don't know how the court is doing it, but if they do it like they did last time, this could take a very long time. It should take a long time because each juror, quite frankly, should be individually questioned. Well,
they are going to have individual questions. They're not going to have a veneer questioning. But you've seen, I know it's the penultimate jury questionnaire. It's 3 pages, and there's been some tweaks made to it. We have not seen the final copy yet. Okay, so I think we want to get your thoughts on that because the 3rd page was concerning just the media. But when Michael, Brian, and I were discussing it, we had problems with pages 1 and 2, which no one else seems to have problems with. So you looked at it. What are your thoughts?
It's a terrible questionnaire, to be really honest. I mean, the truth is I get how the courts want to create efficiency. I get how they are very concerned that they're just going to get this flood of opinions and it's going to disqualify so many people there. But they lay in these questions like, well, will this prevent you from being a fair and impartial juror in the case? And the truth is, jurors don't know that. This concept of fairness and impartiality is incredibly subjective. And one of the things I always talk about in jury selection is fairness and impartiality are 2 separate issues. I think a lot of people can be fair. Impartiality is completely different. And the question is, the individual questions have to happen and you have to talk to people. So as a result of just sort of doing this, I don't mind some of the questions in the questionnaire as a launching point into talking to jurors and having a full discussion of what did you see, what opinions have you formed, who have you talked to, and stuff like that. But then to do this rehabilitation question in the questionnaire, which is, somehow magically by checking the box, yes, I can be fair and impartial there, that qualifies them. That to me is self-defeating in the process here.
Okay, go ahead. I'm sorry.
I was just going to say, especially when there's a lot of people who think this is going to be who think it's an unfair prosecution. And there's a lot of people who I think do have an agenda to get on this jury to try and acquit her. And so that's going to be a challenge. So
with this fairness and impartiality, I was explaining it. What if it seems to me, and you've been through this, so somebody gets up and says they've read about the trial and they think Karen Reed has been improperly charged. Immediately, usually judges will say you're out. But if someone says, no, I think that I've read a lot and I think she's probably guilty, they'll be, well, can you set that opinion aside and be fair? And they'll say yes, and then they're in. And there seems to be this disconnect or imbalance, I feel, that there's a rehabilitation supposedly for people for guilt, but there's never that rehabilitation for people for innocence. I don't know. Am I just making that up?
No. Well, rehabilitation on the whole, whether it's for guilt or for innocence, in my view, is impossible. And to a certain extent, it's actually even disrespectful to a juror. because people are people. They form opinions on stuff. Now, to say to someone, you have this belief, and then to then apply that societal and social environment pressure to say, well, are you telling me you can't be fair and impartial and listen to the evidence in the case? Well, jurors want to feel like they can be fair and impartial, but then to say, setting aside an opinion belief is saying to a juror, your opinions aren't valid. Your beliefs aren't valid. But that being said, that's why this process can take some time, because some people maybe have seen a couple of articles and they really don't know anything about the case. And as a result, they may be able to say, yeah, I've heard some things, kind of have this impression. Yeah, but I understand. I can do it. Those people should be fine. But there's a lot of people who have read about this case, followed the case, talked to their friends and families about the case. Whether they believe she's guilty or whether they believe she's innocent, how do you set that aside?
Yeah.
You can't.
Yeah.
You know, this is a case I describe as a Mars case, meaning unless you're from Mars, you've heard stuff. You know, the level of what you've heard may be varying from person to person, but that's why you get the big money. How do you, when you're going through this process, find out, you know, ferret out those that want to be on the jury for whatever reason?
The stealth juror, as we call it, right?
Those that aren't able to truly set aside. And what are the tells that you, and studying these folks, say, this person says they can set it aside, but I'm concerned because of A, B, or C?
Well, first of all, you're just checking on the volume. You know, just how much have they steeped themselves in this? So that's one tell. If they've steeped themselves in it and they've read, you know, what you consider to be prejudicial to one side or the other, then that's one tell. The other tell is, quite frankly, you have to do a little bit of social media searching and figure out who's been online, who's commented in chat boxes, who's been on the TikTok or Instagram giving opinions about the case. So that's one thing. The other thing from a nonverbal perspective in court is what I kind of look for is the too perfect juror. The person who's really trying so hard to look like they're giving exactly the right wording on the answer. They're giving those things to say, oh, yes, I would be able to follow the judge's instruction and follow the evidence from the witness stand. And they're saying things that look like they've sort of scripted them out and planned them ahead of time. And that to me says is a red flag of somebody who wants to be on the jury. Let's face it, most jurors don't want to be on a jury. That's the natural inclination. So somebody who really wants to be on there typically kind of wants to be there. There are jurors who are like, I really want to serve the system, but they're a little rarer these days.
As a matter of fact, I always tell the story, and I've told the story before, Richard, that we were in the middle of the Spector 1 trial where we had the hung jury, you know, and you helped pick that jury. And in the middle of it, we woke up to Philip having given an interview in British TV to the BBC saying that his life was in the hands of 12 people who couldn't get out of jury duty, right?
Yes.
So most people wanted to get out of jury duty, but when you get a high-profile case, they want to get into jury duty. You know?
Really true. It's really true. It's crazy.
It is crazy.
I always like to see, Richard, at least one alpha in my box. You know, maybe two, but that could be problems if they're at odds. What's your goal in terms of personalities with people you want in that box?
Well, I'm glad you asked that, because personality is key in this. I mean, what I talk about when I'm talking about cases, depending on whether you're working with the prosecution or the defense, is you want different types of jurors. So, you know, when you are, if you are looking for an acquittal, you're always looking for leadership, but leadership always carries risk, because unless you are absolutely certain that person is going to go with you, and you're really confident about that, then that leader can take the rest of the jury with them. So I tend to like to balance this out. This is something I talked about with Michelle a lot when we were in the middle of Spector here. In that case, we said, look, we were concerned about one single juror just driving the jury in the direction of guilt. So we said we wanted a very strong, skeptical jury, and we tried to get a number of people on the jury. We had like 3 or 4. If you recall, Linda, we had a vice president of New Line Cinema. We had a guy who was a manager of a law firm. We had a guy who was a producer on NBC News.
And everybody knew the judge in that case. I said it kept the jurors' names from everybody, but we kept getting calls saying, you have on the jury.
Exactly. So I like to tend to spread my risk. I tend to like to have a few different strong personalities because I'm not exactly sure and I want some balance on the jury. That being said, and I think Karen Reed's team wants an acquittal in this case. So I think they're looking at that. When I've got a bad fact case, I'm looking for a lone wolf. An outlier is going to I'm content with a hung jury in that case. So I'm sometimes looking for somebody who's just a little bit out of sorts, not going to get along well with other people. When you're on the prosecution side, you need unanimity. So you need people to get along. So when I was working, I did a DOJ case with in the Kwame Kilpatrick case for the Detroit hip hop mayor and stuff. And they needed a consensus jury. So we really wanted to we looked for two things. One is leadership, and two is the ability of jurors to literally work together and get along. Because ultimately that's the personality dynamic when you look what you're looking for on the prosecution side.
Now we heard from Aidan Carney, Dr. Turtleboy as he's known, that the juror in Massachusetts, as you know, in Massachusetts, the judge selects the foreperson, okay? They get to choose the foreperson. And Hernandez, if you recall, that worried us because the one foreperson they chose, we felt was the foreperson who wasn't going to get along with the other 11 jurors who were we really felt we were going to be voting for not guilty. But here, the foreperson that she selected was a retired police officer, and apparently the defense was happy with that, but it turned out that may not have been such a good decision. Why is it that having and also I point out that Mickey Sherman in the Skakel case that then I was responsible for helping get overturned by hiring the trial team, to get it, the appellate team, wanted a police officer on the case because he felt, well, if I can convince a police officer of reasonable doubt, then I can convince everybody. Why is it that a former law enforcement person is not necessarily a good pick for a jury like this?
Well, from the prosecution standpoint,
it's a great pick, right?
Well, not necessarily. Because,
isn't that interesting? Okay.
Because the problem when you take a look at similarities in the group. So if you're looking at people, the problem is that they also can be hypercritical of what they're doing. So if they're a go along, get along guy, then maybe that would be a difficult choice. Quite frankly, both sides are going to be scared of a choice like that. Anybody involved in law enforcement, and the defense usually is going to knock them off in a heartbeat. So just because you just can't take the risk on that. But you may be sitting there going, this officer, you take a look at the personality, as Michael said, you take a look at the kind of officer, you do a little research into who they are, you ask some people, and then you say, you know what, I'm going to make my pitch to them. This is an improper investigation, or that they fudge this evidence or something like that. And this is a guy who knows how that works. And so that's the kind of the balancing and the characteristics that you're always trying to do when you're doing this kind of forecasting.
So let me ask you 3 questions, knowing nothing about you.
I object. Oh, sorry.
Okay, I'll ask one question. Knowing nothing about the case, what question is left out of this jury questionnaire that should have been in this questionnaire, if you know? And if you can't answer that, I'll go to question number 2 because I'm filled with him, which is, what is your ideal juror for the prosecution and your ideal juror for the defense? Well,
let me do ideal jurors first, and then I'll come back to the questions that were left out. The ideal juror for a lot of jurors are reliant on law enforcement. You want a person who is deeply associated with the community and who relies on law enforcement, who has a kind of an affinity. You're looking for neighborhood association people. You're looking for neighborhood watch people. You're looking for people who have a stake. You're looking for stability and people who have sort of a trust in authority and think there's somebody there. So it's really an attitude, and you're looking for stability in employment. You're looking for stability in they haven't moved around a lot, and any sort of affiliation with law enforcement. They're involved in the community. That's typically who I want from a prosecution standpoint in there. The one of the biggest challenges the prosecution has in a case like this is circumstantial evidence case. And so you really have somebody who's going to kind of want to put those pieces together. So they've got to create a good story, and you want people to be able to say, okay, so I'm looking also at what are the shows that they watch? What are the books that they read? What are the documentaries that they see, and things like that, to kind of think, who wants a good story here? On the defense side, I'm looking for, obviously you're looking for conspiracy theorists. That's the main thing that Alan Jackson is going for here.
Can I stop you right there, because you mentioned Alan Jackson before you finish, and I just want to tell our viewers, but they may not know, Richard, when he helped me pick the jury in the Phil Spector 1 case that we had the hung jury for, Alan Jackson was our adversary. Alan Jackson represented the state of California. So we all spent 6 months in the courtroom together with Alan Jackson. We know him well. And Michael's actually talked to Alan Jackson about me. He apparently loves me. But, there was that mutual respect, because we were two warriors that were fighting at it. But for those who don't know, Richard knows Alan Jackson very well from that case and how he tries cases. I'm just interrupted you. I'll let you go on with that.
No, it's all right. I mean, Alan is very good, very sophisticated. And as we've seen in this case, he is a formidable adversary because he has used every tool at his thing. Typically we worry in pretrial publicity cases about the prosecution who have, the story gets out about what the allegations are, and then the pretrial publicity builds from that. Alan Jackson has taken the initiative in this case to be very forthcoming with the media. He's arranged, and Karen has arranged for all these interviews in Vanity Fair and things to get their story out. So they've been trying to do this balancing act on things. And quite frankly, so getting back to the jurors, people who obviously feel some affinity for Karen Reed. I mean, those people who are sort of middle-aged professionals, women who think, hey, this woman's just involved in a relationship, and all of a sudden she gets in this terrible accident that happens and stuff. So that kind of people who can identify with her, she's been incredibly relatable in all the media stuff. And so you're looking for people who are going to make that kind of connection to her, obviously conspiracy theorists, also people who are, you always got to take a hard look at engineers because, where they're at in Massachusetts, it's a very highly educated community too. So that's a double-edged sword for both sides. But for the prosecution, you don't want people who are going to overanalyze the evidence. In other words, people what I call create their own reasonable doubt. This is so that's the double-edged sword that I think the defense is looking for in terms of their ideal juror.
Well, let me just tell you that we have Terrence Cox. Thank you, Terrence, for that donation. Hey, Richard, it's Terrence from I'm Not a Lawyer, but with Melanie.
Hey, Terrence.
That's really great. And another one of our people from Shy Gal, who's one of our moderators, also Richard. When you answer the next questions, could you also talk about whether you think AI could be a help in the future to help pick a quick jury?
AI, the AI question. AI is in everything these days. You always have to answer an AI question. So here's my deal on AI. AI is a good tool in terms of collecting information quickly. That's great. But the problem is the accuracy of that information. The other thing is that what AI can't do is tell you who the person really is. They can collect all this stuff on the internet, but how accurate that information, because let's face it, we all have our self-image on the internet, how accurate that is to actually who we are and how we're going to make a decision in a very difficult case, completely different. So I don't think AI is that useful a tool. I think there's a lot of buzz about it, but for me, I wish, one of the things I always say is I would be comfortable for artificial intelligence as long as we get better at human intelligence. I just think we're not, and especially emotional intelligence, because a lot of these cases, you're understanding from a jury consultant's perspective, you are tracking not just the evidence and the logical thinking of how a jury is going to interpret the evidence in the case, but how their emotional reactions are to the evidence and how that's going to form how they interpret the evidence in the case. And that's something AI can't do.
So what's the one question that was left out of this thing that Michael Bryant went through and discussed with our viewers?
Yeah, objection, you're badgering the witness. But, yeah.
I'm complimenting my host, my co-host.
So the best question you can ask, whether it's in a questionnaire or whether it's an open court, is to a juror, is a very vague question, which is just, what did you think about what you saw? Just
whatever that was, whatever
yeah. You saw, heard, or read, what did you think? Because just the what did you think opens up a floodgate, because the truth is most of these questions are narrow questions. What did you see, and did it do something to you? But it's not asking that open-ended, because this is the craft of jury selection, is in really getting jurors to explore, which sometimes they don't know how they feel about some issues that they've seen about. So you got to create space in the courtroom, whether it's on the questionnaire or whether it's in voir dire, for them to truly express and explore. Yeah, I saw that. Was there anything in that you found interesting or troubling or something like that? Yeah, I saw this piece. What was it about that? Oh, well, this bothered me because da 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 da, or this I saw because this, and I had questions. That will tell you reams, much more about the person as opposed to those close-ended yes/no questions.
Yeah, those are brutal. And the questionnaire, of course, is designed to kind of narrow a giant pool to workable numbers. And we can go over those actual numbers in a minute, because I think it's instructive as we get ready for this. But my goal was never ask a yes or no question. I don't want that simple. Do you think you can set aside any biases and judge this case fairly? Yes. Well, that's useless, you know? So I get that. And I don't think people put as much importance on that as they should have. And you obviously know how important that is. So let me ask you this. This is kind of a tech question, old school question. I've had my Post-it notes out and showed, here's how I used to do it with the Post-it notes, and you peel them off. And Michelle said there's still some of that going on, but you're doing research on these prospective jurors in real time, right? I mean, you've got names, but you're there keyboard warrioring it and seeing what people are doing on their social media, right?
Well, depending upon how much time you have, yes, you're either doing it in real time, or sometimes if you have names ahead of time, you can do this research. We're creating either Google spreadsheets, or there's some juror search programs out there where you can just put this information into. And so you have access to that in real time and take a look at it. Now,
right, juror search programs, really?
Well, yeah, I mean, there's a lot of services now that offer juror searches, but a lot of it is pretty much the same. And you have to be finite in what you're looking for, because you can find out about people's bankruptcies, or you can find out about, the legal actions or other stuff. Sometimes interesting to know, but not informative. So you have to kind of narrow down what's going to give me information. Obviously, in cases like this, you're looking for people who have expressed an opinion about the case and stuff. So you have to be refined in your search, and also refined in how you use those results. Because oftentimes you can pick up on something, you think, that's the thing that's going to tell me this perfect information about the juror, but you want to create a whole picture because there's never one thing. You're really evaluating the personality, Michael, as you said. You're also the decision-making dynamic and sort of how they work in a group with each other. You're going to find out also how their life experiences and their belief systems are likely to interpret the evidence in the case. So that's kind of the craft or the art of trying to develop a jury profile.
Micah, before we go on, I'm glad you got the mug. I know you posted a picture of the Justice Serve TV
Yep,
mug,
there it is.
and I'm glad you got it. So,
Yep.
Richard, now we have two other areas to go into. And I don't know, Michael, Brian, how do you want to do this? You want to start talking about how an alternate juror who wasn't selected in the first trial is now on the defense team? I have views about that because I think that she's there not only to give information, but any information she gives now becomes attorney-client privilege. But you mentioned, Richard, articles. There's a Vanity Fair article that just came out on this, right? Right, Michael?
Yeah.
Yeah, let's start with the statement from the juror, now defense attorney. And I don't want to dwell on it too much because reading on TV is not my favorite thing to do. But this was a statement that she had made about the process and about being on that jury, and really about her disappointment, right? Have you had a chance to read this too, Richard? Right? You got this?
Yeah, I took a look at this.
So, she's got even where she references down here, perhaps the Norfolk County District Attorney's Office should be more focused on remedying the systemic issues plaguing it and affiliated police department rather than continuing to spend millions of taxpayer dollars prosecuting a case with so much evidentiary issues that it calls into question whether they're even following their ethical obligations as prosecutors. I mean, she brings to this, or brought to it to the point where she was dismissed, a pretty even hand, I thought. So now she brings that to the defense table. What's your thought on that? And I'm just going to guess you've never seen that before, where a former juror is now on the defense table.
On the table, no. I've heard of prior jurors in cases where there's been a hung jury being contacted, being asked about the case, being given information about this case. The defense has lots of juror interviews from the first trial in this case.
Sure, but she's sitting there now going through the jury selection process from a position very few people have.
And she didn't deliberate. So
right.
they have the affidavits from the people that deliberated. So they know that. What does she bring though now as a non-deliberate juror? And by the way, she apparently wore pink one day, and people said that meant she was fair. I'm wearing pink. It's only because I was told to me at Dolce & Gabbana. Don't read anything into it.
It is lovely. But here's to be honest, I don't think she brings a lot. And I'll tell you why. She has stated her position very clearly. She thinks this is a bogus prosecution. She is clearly an advocate now. She's also an attorney. The difficulty is that I don't know how objective she actually is in looking at this. I mean, she's made her statements very clear. So I think she wants to reinforce the things that Alan Jackson is doing. If somebody who's useful to his team would be employed is actually somebody who is pro-prosecution.
Interesting. Why is that?
Well, because he needs to know his vulnerabilities. If he's going to defend this case, wants to know who are the people, and she didn't deliberate. So what he really needs to know is who are the people who were more likely to convict, what moved them, what were those things, because each side is trying to learn what happened in the first trial and everybody's doing a revamp of their case.
Well, wouldn't you agree that even though she didn't deliberate, and they're not supposed to be discussing the case during the course of the trial, they get to know one another, and I flash back to my personality reference. She's going to get a very good sense of what people are like, what sways them, what their likes and dislikes are, maybe what triggers them. And obviously, she's not going to get to have that kind of exposure as she's helping pick this jury. But there might be some gut sense about different people.
It could be. I mean, there may be some added value in terms of just understanding how she felt when she went through the process. the challenge here is that she is a sophisticated juror. She's an attorney. I don't know what kind of litigator or what kind of attorney she was.
Yeah, she was not. She was more in
Employment law.
transactional for the
Employment law.
most part.
So
and, yeah, not,
in that regard, she does. I don't know if she did jury trials as an employment lawyer. Or she was just mainly
probably a lot of board, board presentations and labor board, that kind of stuff. So less adversarial, that's for sure, and unlikely in front of a jury.
So that to a certain extent, I don't know. She may be incredibly valuable to them. I don't know what her perspective is, but just because she's making that statement, I'm a fair-minded. Every juror is going to say I was a fair-minded juror after a trial, but she's very clearly got an opinion here, and the temptation walking in. This is the challenge I always have when I'm walking into a case. Is one of my hats is an advocate, whether I'm working for the defense or the prosecution. That's only one of my hats. The other hat is I want to put on a juror hat and be honest. Here's the things I don't like that you are doing to my client. Here's the things that I want to hear. Now, she may be, if Karen's going to testify in this case, she may give some valuable feedback as to what happened in the first trial and what things she liked and didn't like about her testimony and stuff. So that could be valuable.
I mean,
But
in terms of if they decide to put her on the stand, which I doubt,
I
one of the things you mentioned was the publicity. The defense has gotten a lot of good publicity out of her because the statement that she made about this, suggesting this was an unfair prosecution, and now the Vanity Fair article that just came out, the second one, doesn't that add to what you were talking about, that Alan Jackson has made this a public case and is kind of trying to level the playing field with what prosecutors normally do, which is like, you're guilty, you're guilty, you're guilty?
Yeah, I think that's a lot of it. So how much he actually uses her, we'll have to see. There might be some feedback. I mean, there's valuable. It's sort of an ongoing focus group, but she's so sophisticated. She has such a knowledge. She's not listening to it for the first time. So that's when we do. So every once in a while we do shadow juries in a big enough case where we will hire people who look and sound like the real jury, and they sit in the courtroom and they talk to us during the case and say, I'm confused about this issue, or I didn't like it when that witness said that. And that helps us modify the case as we go. This woman has seen the case, so she already has opinions about it and stuff. So the hat that she's wearing is really one hat, when being a juror hat. And also, one of the hats that's important is to be an opposing hat. That's one of the challenges I have, is I'm always pushing at my clients and going, nah, that's going to suck.
And they could use her for that. They could say, what did we stink at? What did we really fail at that we could do so much better? I think she could be helpful with that too.
That's the most useful conversation they could be having with her.
Yeah, because I guess they don't want to be having that with the jurors who've given them affidavits who said Karen Reed is not guilty, because they want to keep them cemented in their opinion should that issue ever come back, even though today the appeal was denied on the double jeopardy here. So,
That's right. If you missed that right off the top, that was, and you were wondering why there's this ruling already. Yeah, there was. Before we move past questionnaire, I have to tell this story I've told before, Richard. Questionnaire passed around in a civil trial I was doing. Everybody's scrambling, culling through them. We get to the individual voir dire part, and we noticed that one of the guys that is now in the individual voir dire had listed at the bottom of his questionnaire that he was a Nazi. We just happened to miss that somehow. So things get by. Things are happening fast. We did thank and excuse him at that point.
Yeah, so we do have a question from Kristen from Manhattan, $20. Thank you for the donation, Mr. Brown. I think there's Mr. Gabriel. Is in a complex case with competing facts, how would you position reasonable doubt to make it clear and convincing? Good question.
Yeah.
Great
Clear
question.
and convincing. Yeah, I mean, it's, the important part is clarity. Is, the two things we're looking for in a complex case is, number one, how do you simplify it? And how do you tell a story? Because the truth is that sometimes these complex cases, they kind of go in piece by piece, but it doesn't tell a continuous story of literally how this happened here. So, I mean, and what you're trying to do is, the real sophisticated attorneys that I know also try to adopt what the other side, like let's say you're in a prosecution case, make it clear and convincing. You're going to try to take in what Mr. Jackson's perspective, what his main points are, and try and incorporate that into your own case, because you can't ignore it. You know his arguments already. So you need to know your vulnerabilities. You know about the texts. You know about the stuff, internally in the police department and stuff like that. So you have to get in front of that, own the problems in your case, steal the thunder of whatever the defense is, then tell that simple case and really connect the dots. Because ultimately the prosecution has to say, this is the only explanation, especially in a circumstantial case.
Oh, so are you suggesting that the prosecutors call now fired State Trooper Proctor on their case to get ahead of it? Or is there some other way they get around those horrible, horrible texts?
I don't know if they call him, because I can't imagine that, because then he's going to be cross-examined for days and stuff on whether he does that. But if it comes in, if the texts come in, and they know that that's going to come into evidence, you get up an opening statement and you address it. And you talk about, this is what you're going to see. You're going to hear about an imperfect police. You're going to hear, and you have to explain why. Police they were very upset. One of their comrades, was killed, and they were upset. And they, unfortunately, and you have to explain that, because otherwise that residual thing just hangs out there.
That's been my kind of position, is I'm putting him on. If I'm the prosecution, I'm putting him on, and in that opening statement, I'm going to tell the jury, you're going to hate this guy. You're going to be disgusted by the things that you hear from this former trooper. But don't let that clog your mind as to what's really happening. Don't ferment this. Don't.
And if you're the defense, what's your main point in your opening statement? If you, I really think that we know Mr. Yannetti is not doing the opening. There's been this movement to have Mr. Alessi do it, but I really think
I did a poll on that, by the way.
I know, I saw that.
Oh, you saw that?
I think Alan Jackson has to do that open. He's a strong personality. He knows the case inside out. I think he's got to set that table this time.
He is 49% right now. That's the latest, with almost 1,000 votes. So,
yeah, I mean, on the defense side, you're telling the same story. I mean, you are making it very compelling. I cannot see, to a certain extent. I mean, Alan is doing what we didn't know, Jay. The truth is.
Oh, did I forget to tell you, Richard was also a jury consultant in the OJ defense.
OJ too, but
trial consultant.
Alan has learned that he's not defending Karen Reed. He is prosecuting this case, so he is putting on his prosecutor's hat, and he is creating an alternative prosecution in this case. So he is not. By doing so, he's hoping to acquit Karen Reed. But it's just a different perspective in terms of just saying, no, she didn't do this. No, she didn't do this. No, she didn't do this. Reasonable doubt. It is, no, I want to take a look at the roots of this prosecution and question how this even came about. And if you find that there's reasonable doubt, even before they even get to the evidence and stuff, then that creates reasonable doubt. So it's just a different frame for him.
And I think that causes him some challenges too, because we have heard, from people chatting about the case after the fact, hey, they never proved there was a conspiracy. So I think when you take that aggressive type of defense, some people interpret that as something that the defense has to prove rather than poking holes in the prosecution's case. So I think if you go that route, you've really got to reinforce, we don't have to prove a damn thing here, but A, B, C, and D look kind of weird.
Yeah. I mean, it is, beyond reasonable doubt is tough in a case like this, because you do have two stories that are going on. What that does is creates sort of this gravitational pull toward preponderance standard, where, people go, which side do I believe more here? And that's, so talking to them about really, and I have no doubt that Alan's going to spend a lot of time on what reasonable doubt is and what the standard is and how to get there and things like that. So I think that's he's going to hit that. But you make a good point. I think that sometimes it can create a challenge for the defense because they're going to say, okay, did you prove it?
Oh, wow. Now we have another area we want to talk to you about before we let you go, and that is the fact that there was a motion to dismiss that was made, fully throated, as Alan would call it.
Fully throated.
And all of us who are watching know that the judges seldom have the, shall we say, will seldom issue a motion to dismiss, even if you've had police misconduct, even if your lead investigator has been fired for misconduct and all. They just don't do it. But one of the issues that really was an interesting issue that Michael Bryan and I talked about was the discussion about whether or not it was improper for Judge Canone in the first trial to let a juror go. Juror number 3, I think it was, go. I think they at first identified her as Juror A when they were trying to keep it secret. And they had a transcript, which I know you've read, about whether or not she was engaged in any in discussion or heard any discussion at either an American Legion or Knights of Columbus about a month before they questioned her. And the transcript that we see indicates that she said she can't remember. She was drinking if people mentioned anything to her about the case. But we had a problem, Michael Bryan and I, in that she didn't, since she was drunk and she said she was drinking, she didn't say that she participated in that. Do you think this was an improper dismissal, or could the questioning have been better? Should the defense have gotten their hearing to say, well, to let her say, well, maybe, I didn't hear it, but I know clearly I didn't participate. The fact that this seems to be an imperfect transcript, an imperfect inquiry. Is that, I guess, is what I'm saying.
Yeah, and that is the difficulty. A lot of judges are not used to these kinds of cases and stuff. And so how to conduct a proper inquiry is very difficult. But yes, I think better questions could have been asked. I mean, it's pretty simple to kind of go, who was there? What do you remember? What did you recall about the conversation? Do you recall being affected by that? There's just a lot of questions. It doesn't take that long and stuff to kind of figure it out. So I think better questions absolutely can be asked. But the bottom line, as you well know, all about the sound discretion of the judge. And so,
oh yeah. And what bothered me most about, even in her decision, she acknowledged that the juror did not recall, I was drinking. But she said, and this is in her decision, I would not be surprised to learn that there had been conversations at some point that would affect her judgment. So I'm going to get rid of her now. I mean,
and that is the biggest challenge this judge has in this case is she's dealing with a really unprecedented situation, which is how do I draw the line? I want to tell people, don't expose yourself to this. How do you prevent that kind of exposure when it's everywhere and everybody's talking about it? Somebody walks into a coffee shop and somebody's talking about it. Are you going to dismiss that juror? It's almost impossible. So I think the judge probably drew a too severe a line in this and just jettisoned the jury when they probably could have done a better inquiry.
Well, I don't think anybody's going to suggest that she is shy about making decisions that seem to impact the defense.
Let me go through 2 other things. Let me just make a point.
That was a little question. Did you want to do that question?
Yeah, no, in a sec, to Miss Karen Stoppel. Dishonored allegiance judge, we're not going to say that in front of a jury. No one's going to say. They're going to admit that he's fired, all right? Because that's mincing words, okay? Both sides are going to say he was fired. Because it's not only discharge sounds like, oh, it's kind of namby-pamby. The prosecution wants to get away from him. They want to get away from him being there, and the defense wants to show that. So we have our facts right. We know this case.
I almost prefer dishonorably discharged. It has kind of a more weighty, people get fired all the time. From all kinds of jobs.
Fired.
But dishonorably discharged sounds like something nasty happened, and it did.
It all did. So, but Aldante, thank you again for your, I guess, Canada. You still love us from Canada. Thank you very much. This corruption has been abundant and allowed for years. So who's to blame? The swamp is deep. Cops or the Commonwealth or the judicial system. In that. And I think what she's also talking about here when we talk about the jurors is supposedly 3 Dedham cops overheard this. This juror may have been taped. I mean, it raises all sorts of issues. The jury being followed. How did Dedham cops know about this? Was she being set up? All sorts of stuff that wasn't discussed. So I guess just mention that in light of this question that we have. Yeah, I mean, that's where, these cases are self-perpetuating. The challenge is that typically you impanel a jury, the evidence goes on, right?
and that becomes the case. But again, as I learned way back in OJ, in these cases, stuff comes up all the time, which actually then gravitates. Does it affect the jury? Are there other evidentiary issues? Are there additional witnesses that sometimes come up because somebody overhears something? They contact the district attorney's office or they contact the defense and they say this, and then a motion's made, and then all of a sudden you're off to the races here. So the problem here is, how, when you're telling a jury, you have to focus just on the evidence in the case, but the evidence itself sometimes is constantly evolving. It is difficult. That's why, I wrote a book called Acquittal, in which I talk about these different justice systems here. And there's a collision in these cases between the First Amendment and the Sixth Amendment here, because free speech is free speech, and we have the freedom of the press and stuff like that. But to a certain extent, it can impinge the rights of a defendant to a fair and impartial trial. And sometimes it can impinge the rights of even the prosecution to really having juries decide the case only on the evidence.
And that's the challenge that you have every time you take on one of these cases. You're hot off the ASAP Rocky acquittal. What's going on now with you?
We just finished a Mexican mafia case here in LA, but we also do a lot of civil work. So we do a lot. That's a majority of our cases. We do those kinds of cases around the country. But there's always something percolating. I've got a whole crew that's fantastic, including Michelle. And so no rest for the wicked.
Yep.
No, you're absolutely great. And one of the things that I always say to people is that you should remember that in civil cases, usually when you're dealing, you have a client in a civil case, as a corporation, whatever, they have a lot of money to have a trial consultant, to have shadow jurors, to have mock trials, to have focus groups. It's very rare that you have a criminal defendant that has those kind of resources. So in some ways, criminal defendants don't have the ability to have the fairness, the equality. Even prosecutors can hire trial consultants in cases where the defense may not be able to, especially if it's like a PD case. So that, it's a luxury in many ways to have Richard, but everybody, even if you can't afford a trial consultant, can learn by listening to Richard about what you do and how you pick a jury.
And I do want to put in there that the American Society of Trial Consultants, of which I'm a member and a former president, we have a whole pro bono committee. So even though there's the opportunity for people, and we do pro bono work, but it is
a lot, and I can attest to that.
We want to make sure that there is some balance in the scales on these things, because there's a lot of people who can't afford it, who do deserve that.
Yeah. I'm assuming, I may be wrong, I shouldn't ask this question, I don't know the answer. You worked on the OJ trial out of LA, the double murder trial. Did you work on his Las Vegas robbery trial, the one that ultimately got him convicted?
I did not work on that case. Did not work on that case. Yeah.
All right. That, as I've told folks, that's where I got to know OJ, interviewed him, nicest killer I've ever met. But yeah, he definitely went down in that trial. So.
Yeah, he did.
Yeah, and then again, I should say, Rich is more than a jury consultant. They stay with you through the whole trial when you hire them. They're assessing the jury. They can tell you when the jury is fraud, shall we say, and then you just got to stop. It's really a science. It's not what people think, that it's not a science. It's based on a lot of sociological studies. It's based on your experience and all, right, Richard? It's not just picking the jury. It's then, yeah, I always tell people, if you pick the wrong jury, you can't win the case. But you can pick the right jury and then you lose the case should you not try well.
Yeah, no, I mean, you have to be able to. There's limitations in picking a jury. You have only a certain number of peremptory strikes. So you have the pool that you're dealt with, and you have to address the audience that you ultimately have. So part of the evaluation is, once I've picked the jury, who are these people? What is the story that we can tell to them that's going to make them go, got it.
It is fascinating, the whole science, the whole process. Anybody who's tried a case knows how important the jury selection process is. And man, I would have loved to have had your expertise a few times. So keep up the good work, sir. And
Jason Hodges actually says that Karen Reed needs you.
Yeah,
I could say it wouldn't hurt. So
thank you, Richard, for your time. You're always so gracious with your time. It's unbelievable.
Really appreciate coming on with you guys. It's been fantastic talking.
Pleasure to meet you, Richard. We'll check in with you and see what else is happening as time goes on. Thanks again, man.
Sounds
Thanks.
good. Take care.
He's
That
great.
it's fascinating stuff. I mean, it really is. You got to get into people's heads, right?
Right, and as I said, he does a lot of pro bono work. When we were doing the case that came back from the Supreme Court in Tennessee, the House case, he did, and that's when I went to Maynardville, Tennessee, to do my jury questionnaire. He did, because we didn't have money. It was the public defender's office there doing it, and I came in pro bono on behalf of an organization that was helping them. We went to Tennessee a number of times, but he helped with our jury questionnaire, which was the most amazing experience I ever had, because the prosecution ended up dropping the case because of some DNA issues that came in afterwards. But we had the jury questionnaire filled out, and that's the story I tell about having, and I use it when I teach. A question was, what do you think, of defense attorneys? And the answer was, and it wasn't spelled right, but that doesn't matter, because none of us can spell these days with spell check. And with me, no one even knows I can spell the way I type. But the answer was, they're just doing the job, and we're going to convict the person anyway.
Yeah, geez.
Best
Good to know.
answer I've ever seen. But it was
Yeah.
a great answer, because it put in perspective how jurors feel.
Yeah, sad. Look at Alicia Southern. She's curious. State can hire a jury consultant. When? How? Limitations. Well, they can hire special prosecutors for a couple $100,000, right?
Right.
So, as long as somebody gives them the okay, they can spend those tax dollars.
Thank you for someone saying that Karen needs me. Alan Jackson hasn't called me, so if he calls me, we can see.
Yeah. Another Pro Hack VJ coming up.
I've had so many of them. I pass every single one of them because I've had no issues with my record.
All right, I think we got to everything, right?
Well, we have to everything, and we should tell people we are going to be on the air unexpectedly tomorrow at 9:45 a.m. Why is that?
Before the hearing? Yeah. As we learned from Aiden yesterday, we had Turtle Boy on yesterday, and thanks to everybody who tuned in. We had a little time warp shift there, and a lot of folks have picked it up on the replay. So Aiden Carney, Turtle Boy, will be in court tomorrow because there has been an alert sent out by the court. We need an emergency meeting, a hearing that follows the decision that there will be information turned over in Turtle Boy's phone, the phone that has been out of his possession for, 2 years now?
Right, and they did file, Aiden Carney's attorney, Mr. Brettle, did file responses, and I guess everybody's going to be in court tomorrow, right?
Yeah, it should be very interesting. Obviously, the goal on the prosecution's part, and this is being done, even though it's by Cosgrove, because he's the special prosecutor on the witness intimidation issues. It's really for the benefit of Brennan, right? Hank Brennan, the special prosecutor in Karen Reed's case. So they want what's on that phone. They think there's something on there that is going to be so incriminating that will show consciousness of guilt on behalf of Karen Reed in somehow creating an alibi, shifting the blame for something they think she did in the death of Officer John O'Keefe. So it's going to be amazing. It'll be at 10-ish tomorrow morning. It could be over in a heartbeat.
Yeah, and Aiden did tell us when he appeared on our show on Wednesday, he did tell us that he had just gotten that about just before he came on the air.
Yeah.
And they were dealing with it. They actually wanted the hearing yesterday, I think, the prosecutors, and I guess it was pushed off to today because, I mean, it's hard when you get notice, at 5 o'clock that there needs to be an emergency hearing to get this stuff turned over when you've had it for so long. And all. So we're going to be on there then. And then tomorrow at 5 o'clock, we're going to have Doug Weinstein on a regular show live. Our friend Doug from YSL will find out what's going on there. But the reason why he's on is he's expressed some serious issues, shall we say, opinions about both sides in this.
He wants her to shut up. Right.
He wants both sides to shut up. He wanted her to shut up, and he thinks the prosecution was outrageous, making the motion for the attorney-client privilege. Like, get real here. But we're going to hear from him because it's going to be a little bit of different opinion than we've had. And then at 6 o'clock, so and we love Doug, and and you have to listen to it because there's people that feel that way. You have to listen to all sides, as Richard Gabriel says.
Of course.
Sometimes listening to the other side tells you where you're going wrong on what you're doing. And then at 6 o'clock tomorrow night, we're going to go on Will DeGlara's show.
That's right.
And be his guest on his show. You forgot about that. You're going to leave me out there. So, basically, we have no life, okay? We are all viewers watching the Karen Reed trial and trying to get ready for the Karen Reed trial. But we will see you tomorrow at 9:45. But, before we go, I have to make an appeal. And that appeal is there's so many of you who've been watching tonight. Richard donated his time to us. Please hit our like button. Please, 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 pretty please. subscribe, share, and notify. But the like button, as we've told you, gets us into the algorithm. And obviously, the subscribers are going up. All of you, the word's getting out that we're small, but we're mighty. And we are the place that people come to be interviewed. We think we have street cred. And I think that the guests that are coming here have acknowledged that, because they're coming here because they're going to think they're going to get a fair shake, fair interview, and you're going to get the real information. So hit that like button.
That sounds like that's a great pitch. I like that. We've had a couple of questions, including Glenda asking where Domino is. I heard him scratching at the door, but it's closed today. So unless he magically grows some hands and can turn the knob, I don't put it past him. But at this point, no, he'll make an appearance, I'm sure.
Yeah, and yes, we do have the best chat. I just say that on the way out.
Yeah, we have the best mods. That's why.
And the best mods and the best producers and the best everything. So you got to hit that like button before we go. Make them happy, please, for all the hard work they do pro bono for you.
Yep. All right, then. Tomorrow morning. Until then, I'm Michael Bryant. Try to do the right thing.
I'm Linda Kenny Bodden. See you tomorrow morning.